and welcome to the virtual Mary Minor Cook Athenaeum. My name is Chris Agard, and I'm one of your 3 Ath Fellows for this year. When you think about the Constitution, what about it stands out to you? Is it the document's longevity? What about its ambiguous language? Do you think about how the judiciary should interpret the contents of the Constitution? Some, such as the late Supreme Court Justice Antonin Scalia, have argued that the Constitution must be understood by its original meaning, under the context under which it was originally published. Well, what exactly does that mean? Today's guests join us to discuss this compelling concept. Sterling Professor of Law and Political Science at Yale University, Professor Akhil Amar teaches constitutional law at both Yale College and Yale Law School. Before joining the university's faculty in 1985 at 26, he graduated summa cum laude from Yale College and proceeded to obtain a law degree from Yale Law. Professor Amar has received awards from both the American Bar Association and the Federalist Society for his work, and has been cited by the Supreme Court in more than 36 cases. In fact, he ranks among the United States' 5 most cited mid-career legal scholars. In addition to frequently contributing to various news outlets, he is the author of dozens of law review articles and several award-winning books. Additionally, Professor Amar clerked for then Judge, now Justice Stephen Breyer. Professor Stephen Calabresi is the Clayton J. and Henry R. Barber Professor of Law at Northwestern Pritzker School of Law and has been a visiting professor at Yale Law School and Brown University. He has been chairman since 1986 of the Federalist Society's Board of Directors. A cum laude graduate of Yale College, he attended Yale Law School. Professor Calabresi has worked in the West Wing of Ronald Reagan's presidential administration as a special assistant for Attorney General Edwin Meese III. He also clerked for Supreme Court Justice Antonin Scalia and Judges Robert H. Bork and Ralph K. Winter. He is the co-author of 3 books. Professors Amar and Calabresi will be in conversation with CMC's George Thomas, Wolfer Professor of American Political Institutions at Claremont McKenna College, and director of the Salvatore Center for the Study of Individual Freedom in the Modern World. This Athenaeum conversation is sponsored by the Salvatore Center's Lofgren Program in American Constitutionalism. Using the Q&A function, we will accept questions throughout the program to be posed towards the end of the event. Preference will go to students, so when you send in a question, please state your affiliation with the college. Student, faculty, parent, alumni, friend. As always, I must remind you that audio and visual recording are strictly prohibited. Please join me in welcoming Professors Akhil Amar and Stephen Calabresi to the Athenaeum.
Thank you. Well, let me say I'm delighted to have both Professors Amar and Calabresi here. And the idea for this conversation really began as I was reading the new edition of Antonin Scalia's A Matter of Interpretation, where Professor Amar has an introduction and Professor Calabresi has an afterword. And it's really this discussion and the debate on original meaning that we want to pick up with tonight. And so what we're going to do is first just turn it over to Professor Amar to outline his understanding of originalism and the points of contention that he has, not just with Scalia, but perhaps with Professor Calabresi as well. And then we'll just engage in a conversation between the 2 of them before we open it up to questions. So let me turn it over to Professor Amar.
Thanks so much. It's such an honor to be with you, and it's always great to be back with my friend Steve Calabresi. We've been friends ever since we were students at Yale College, and we now teach together regularly at Yale Law School. George, since you did mention the Scalia book, I've got mine right here. Steve can hold up his copy. And when I was invited to do the forward, the introduction to the new edition, my one condition was that I would do it if and only if Steve were invited to write something also part of the volume. As you heard, Steve clerked for Justice Scalia. Steve also clerked for Robert Bork. Indeed, Steve and I actually took a course with Robert Bork together. Here's Robert Bork's book. Steve probably has it a different version. I got the paperback version. I want to read you maybe the The second sentence of the book, this is from the acknowledgments. Stephen Calabresi, my research assistant for the past year, was indispensable in every aspect of the work. And then he goes on with more fulsome praise. And as I said, Steve and I actually took Robert Bork's class together. And Robert Bork said, constitutionalists should be originalists. They should pay attention to the history of the document and its text, and of course, its overarching structure. And that's also a theme of Justice Scalia. And I've come to agree with Bork and Scalia that originalism is indeed the best way to begin to approach the Constitution, to pay attention to its words, the original understanding and context of those words, and the amendments as well, of course, and the overarching structure that unites the document. Now, my own view, truthfully, is that Scalia and Bork, while calling upon others to be originalists, didn't always succeed in being originalists themselves, because to be a serious originalist, you need to know a lot of history. They came to the project somewhat later in life as mid-career generalist lawyers and judges. So what I've devoted my scholarly energies to ever since really taking the Bork class is trying to study the text, history, and structure of the Constitution. And I'm going to try to make 2 points in these opening remarks. One, that we originalists, we have a method, and it's actually, it's not altogether determinate, but there's a lot of objectivity to it, and here will be a test. I'm going to go through many contested provisions of the Constitution and tell you what I think. I'm a Democrat. I voted for Al Gore. And then I'm going to invite my friend Steve to say what he thinks about those very same topics. He's a Republican, a co-founder of the Federalist Society. He voted for George W. Bush back in 2000. And it will be an interesting case study to see just how often a mainstream Democrat, yours truly, and a mainstream Republican, Steve Calabresi, who might vote differently on election day, end up converging on the original meaning, the text, history, and structure of the Constitution in various interesting applications. The second point, and we'll just see, I think we're going to converge way more than we diverge. The second thing that I'm going to try to persuade you of is, in general, what the Constitution really says and means is actually pretty sensible. It's something that actually can provide a basis for all of us in a very divided nation to come together around common ground, a focal point. And in fact, given that an alternative focal point might be judicial case law, I actually think that what the text of the Constitution says and what it means is, on average, in general, better than what most judges have said most of the time for most of American history. Okay, so I'm going to just actually work through what is conventionally called the Bill of Rights, just because I think those are some of the most interesting examples. So we start with the First Amendment, and critics of originalism say, oh, if you take originalism seriously, the First Amendment, freedom of the press, only means freedom from press licensing. That's what Blackstone says. It's only freedom from a thing called prior restraint. But once you actually open your mouth or put words, put pen to paper, you can be prosecuted if you abuse your freedom of expression. I don't think actually that's what the Constitution says or means. Above and beyond freedom of the press is freedom of speech. It comes from actually a different tradition than freedom of the press. It comes from a tradition of freedom of speech and debate in Parliament, from French parler, to speak. Parliament is a speech spot. It's a place for special political discourse. And in America, those special parliamentary rights of speech actually attach to members of the society generally, to citizens, because in America, we the people are sovereign. We're not merely the parliament. And so there is robust, wide open, uninhibited freedom of expression that is promised by the First Amendment, free speech, Indeed, freedom of speech was baked into the constitutional cake even before the Constitution was adopted, and before the First Amendment was adopted. The Constitution arose out of lots of people speaking about whether they were for or against the Constitution in this great ratification year. So robust, uninhibited, wide open freedom of political expression is in the First Amendment, in our structure. That's what originalists believe, and the courts haven't always done that. They didn't come around finally to that point of view, basically until the 20th century. They upheld for much of American history all sorts of restrictions on political expression, from the Sedition Act to repression of abolitionist speakers, and even in the early 20th century, which they shouldn't have. That's the First Amendment. How about the Second? I believe that the Second Amendment, even if originally it was only about militias, came to be understood after the Civil War as about a right of people to have guns in their homes for self-protection, especially African Americans who couldn't trust local cops, local sheriffs to protect them against the Klan. And so the Second Amendment actually affirms a right of individuals to have a gun in the home for self-protection. It's also part of our unwritten Constitution, unenumerated rights, Ninth Amendment rights, 14th Amendment privileges and immunities. The court didn't get around to saying that until actually the last 15 years or so. But that's what the Constitution says. Maybe that's a more conservative application than the free speech one. The Fourth Amendment does not, as courts have said, provide for an exclusionary rule, nor does it provide for an absolute warrant requirement or probable cause requirement. It does require that governments be reasonable in searching and seizing. And if they're not, ordinary, innocent people are supposed to be able to sue government officials and get damages and even punitive damages, and there shouldn't be immunity for police officers and FBI agents when they search or seize unreasonably. And that's not what the courts are doing. That's what the Constitution says. And once again, I think the Constitution's better than the courts. Let's take the Fifth Amendment. It has many provisions, self-incrimination. I believe the right against compelled self-incrimination is a right against compelled witnessing, because compelled witnessing can be unreliable. Someone could be made to confess or seem to confess to something they didn't really do. And the key idea is innocence protection, but people can be, in fact, obliged to provide a blood sample, a DNA sample, a fingerprint, because that's reliable evidence in a way that words aren't. And once again, actually, this originalist conception of the Fifth Amendment, as understood also during the Reconstruction period, is better than what courts have traditionally done over the years. The Sixth Amendment talks about jury trial. It talks about the rights of defendants to jury trial, but Article 3 talks about the rights of jurors, in effect, the community to jury trial. And it says the trial of all crimes shall be by jury. And if that's true, that's my view, then actually jury trial shouldn't be waivable even by the defendant. And what the courts still today haven't gotten there. The Seventh Amendment's about civil juries. Here's one key idea. Civil juries should be deciding in part what searches and seizures are reasonable, what's just compensation in cases where the government has grabbed property and not according to a citizen property owner paid proper compensation. So the Seventh Amendment has close connections to the Fourth Amendment, right of people to be free from unreasonable searches and seizures, and the Fifth Amendment takings clause, which are about property and tort law, and Seventh Amendment civil juries, and not just judges, should play an important role. Let's take the Eighth Amendment, talks about prohibiting cruel and unusual punishment. Justice Scalia, for whom Steve clerked, said, oh, how can it be that punishments that were perfectly common at the founding are now unconstitutional, certain kinds of death penalty adjudications? And my answer is, well, the death penalty for 17-year-olds or for pickpockets, that was once common and usual at the time of the founding. It has ceased to be common. It has become unusual and therefore arguably cruel and unusual. So Justice Scalia gets it wrong in this book, but if we take seriously the method that he proposes to look seriously at text, The word unusual actually is really important here. The Ninth Amendment is a provision that Judge Bork, for whom Stephen clerked, and Justice Scalia didn't take sufficiently seriously. There are unenumerated rights. Some of them are of a liberal sort, the right of privacy in one's home, Griswold, the right of married couples to use contraception. Some might be conservative. Even if there weren't a Second Amendment, I would say people have a right to have a gun in their home for self-protection because that's part of the American tradition. It's an unenumerated right of the people that we could see by looking at state constitutions above and beyond the federal. And this right of a gun to protect one's home is actually an important part of many state constitutions, the American tradition. Truth be told, I don't have a gun in my home. They scare me, but if you want a gun in yours, it's your right as an American. I'm coming to a close now. Let me just briefly tell you about the 14th Amendment after the Civil War, which talks about everyone who's born in the United States being a citizen. That's true if you're born black or white, male or female, Jew or Gentile, gay or straight. That's true whether you're born in wedlock or out of wedlock. It's true whether you're, when you're on the day you're born, your parents are citizens, or as when I was born, they're not citizens, but I'm still a birthright citizen by dint of the 14th Amendment. Even if your parents are here illegally, if you're born in the United States, you are a citizen and indeed a natural born citizen. And that's what the 14th Amendment says, contra what you may have heard from John Eastman or other folks. Every citizen is entitled to basic privileges and immunities of citizenship, fundamental rights that no state shall abridge. At their core, that these rights include what we call the Bill of Rights: freedom of speech, freedom of the press, free association, assembly, religious rights. Fundamental rights are protected against state abridgment, and if something's in the early amendments of the Constitution, or even other parts of the Constitution, the writ of habeas corpus, that's strong evidence. It's a fundamental right. So incorporation of the Bill of Rights is provided for by the text, history, and structure of the Constitution, properly understood. Judges didn't do that for the longest time. They do it now, led by a liberal originalist, Hugo Black, Franklin Roosevelt's first appointee to the court, and conservative originalists like Justice Thomas or Justice Scalia agree with that in more recent cases, like the case that of City of Chicago versus McDonald, applying the Second Amendment right to have a gun in your home for self-protection against states and localities. Finally, the 15th and 19th Amendment are about political rights, voting rights for African Americans, for women. They're entitled to vote equally. They're entitled to vote equally, not just in ordinary elections, but in juries and in legislatures. The 14th Amendment rights of women's equality politically, also supplement the equality rights of civil equality under the 14th Amendment. The 14th Amendment isn't just about race. So in effect, 14th Amendment plus 19th Amendment pretty much equals ERA. And the deep equality ideas of the 14th Amendment, which again do not say race, they talk more generally about birth equality, I would say include birth equality rights, not just of blacks and whites, male and female, Jew and Gentile, but I would say gay and straight as well. So the Obergefell case, I think, is an originalist, can be defended on originalist grounds by appeal to the birth equality idea at the heart of the Reconstruction Amendments. Now, here's what we're about to find out. We're going to first hear a little bit more about originalist philosophy from my friend Steve, but we're also going to find out how much of that he agrees with, even though we don't always vote the same way on election day.
Great. Shall I start, George? Okay. First, let me say a thank you to Chris for that very kind introduction, and to Professor George Thomas for inviting Akhil and me to be part of this webinar. I'm thrilled to participate in this event. Akhil is, along with Gary Lawson, one of my two best friends in the world. I've known him since he was 18 years old. We grew up together, we teach together, we have talked on the phone together repeatedly. He coached me through my first federal jurisdiction class when I started teaching. And it's a pleasure and an honor to be on a platform with him. Second, Akhil is absolutely right. I've voted for every Republican candidate for president since Ronald Reagan in 1980. I assume he's voted for every Democratic candidate for president since 1980. And nonetheless, we agree on all of the outcomes that Akhil just mentioned. And I'll just go over them briefly before turning to constitutional theory, which I want to say a little bit about. I agree with Akhil that the First Amendment protects speech robustly. It goes way beyond prior restraints. I completely agree with Akhil that the Second Amendment protects an individual right to own guns. I agree with him that the Fourth Amendment does not mandate an exclusionary rule. I agree with him that the Fifth Amendment allows for fingerprinting and DNA testing, but not other types of forms of self-incrimination. I agree with what he said about the importance of juries, about the application of the Eighth Amendment in the context of modern times. I agree critically with him about the 14th Amendment and that it is a ban on all systems of caste, and it is premised on the idea of birthright equality. I mean, I think at the cornerstone of the American Constitution, there is the idea that all human beings are born free and equal, and that there are no systems of caste here in this country. So Akhil and I would probably agree maybe 98% of the time if we were on the Supreme Court. Here, every now and then we find a point of disagreement, but not often. But I wanted to add to this by talking a little bit about constitutional theory. And part of the reason why is because Justice Scalia and Judge Bork lived in a world where they had to justify doing originalism. They were surrounded by non-originalists, and so they wrote pieces defending the theory of originalism. Why should we apply the Constitution as it was originally understood? They did not, unlike Akhil and I, have the luxury of actually doing originalism, analyzing cases in an originalist way and reaching outcomes. And I think there's value to the theory, but I think there's also great value to actually doing originalism and seeing how it works in practice. And I've learned a lot from that. And frankly, I've learned a lot from Akhil with respect to that. And one of the most important things that I think Akhil's work shows is that the text of the Constitution, this little document, it's the shortest Constitution in the world that you can carry in the pocket of your jacket. That little document is the best Constitution in the world, in my opinion. And I can say that as a scholar of comparative constitutional law who studied all the other leading constitutions in the world. And it's also the shortest Constitution in the world. And both its excellence and its brevity commend it to us. So let me say just a couple of things about the kind of country we are, the kind of constitution we have, and then thoughts about how to interpret it. I think it's important to remember that the United States is the third most populous country in the world after China and India, the fourth largest country territorially. We have the largest economy of any country in the world, even though we account for only 4% of the world's population. We have the highest GDP per capita of any of the G20 nations. We militarily defend continental Europe from Russia and the East Asian democracies from China. And we have a lot to be very proud about, and frankly, a lot to be very grateful to the framers of this Constitution for. I agree with Ronald Reagan, for whom I worked, that the United States is a shining city on a hill and a beacon of liberty to oppress people all over the world. And one can see that because millions of people try to move to the United States from every continent in the world, and yet virtually no one wants to leave the United States to go somewhere else. Occasionally someone will leave to go to Canada or New Zealand or France, but not very often. I mean, the flow is in, and that's because our Constitution, even though it's 231 years old, gets a lot of things just plain right. It's also, I should also note that the Constitution's age of 231 years is absolutely amazing to me as a comparative constitutional law scholar, because the average age of a constitution today is 19 years. So for this document to have lasted 231 years is really remarkable. And we have to acknowledge that it was brilliantly revised during Reconstruction with 3 critical amendments. It was brilliantly revised again during the Progressive era with 3 critical amendments, and then brilliantly revised again in the modern era. But as amended, it's a superb document. So how do we think about interpreting it, and what method of interpretation makes sense? My thesis, my argument right now is going to be that different texts demand different modes of interpretation. So for example, a poem or a novel may mean many things to many readers, but a shopping list of groceries to buy that your spouse has given to you does not mean many things to many readers. I think the US Constitution is more like a shopping list than it is like a poem, subject, however, to 2 very important caveats. First, when we interpret the Constitution in a case, we have to apply the text of the Constitution to a world which has radically changed since 1789 or 1868 or 1920 or 1945. To paraphrase Judge Bork, for whom I clerked, quote, "The world changes in which unchanging legal texts find their application." We thus need to interpret the Constitution as it applies in 2020, literally, holistically, and purposively. And I want to flesh that out by giving 2 examples. Akhil talked about the First Amendment's protection of freedom of speech and of the press. And he noted that many Americans believed, and the Supreme Court believed until World War II, that freedom of speech and of the press was mostly about prior restraints. But in fact, the First Amendment also says nothing about freedom of expression in radio or television broadcasting, or freedom of expression on the internet. You could read it literally as being only about speech, vocal utterances, and only about printing presses. But I submit the right way for an originalist to interpret the First Amendment in 2020 is to read it as protecting freedom of expression generally, including with respect to technologies of expression that did not exist in 1789. So the text of the First Amendment has stayed the same for 231 years, but the world has changed, and so cases come out in a way that does not literally apply the words freedom of speech and of the press. A second example might also be relevant. All of you know that Congress has the power to raise armies and to provide a navy. Nowhere in Article 1, Section 8, in the various grants of power to Congress, nowhere is there an enumerated power of Congress to provide an air force or a space force. But it's absolutely obvious to all of us in 2020 that the funding of an air and space force is a necessary and proper exercise of power for carrying into execution Congress's power to raise armies and provide navies, because without air and space cover, navies and armies would be obliterated. So once again, the 231-year-old text of the Constitution hasn't changed, but it applies in a new way because of changes that have happened in the real world. So that's one caveat to my analogy of the Constitution to a shopping list. A second caveat is that the Constitution contains some fairly open-ended language in places that invites change over time. The Fourth Amendment bans unreasonable searches and seizures, but our idea of what's unreasonable changed after the September 11th terrorist attacks. Prior to September 11, 2001, we would have thought it was unreasonable to undergo the sorts of searches that we now undergo every day when we go through an airport. And that's an example of a broad term applying differently in one period of time from the way it applies in another period of time. Another example is, I argued, the framers of the 14th Amendment created birthright citizenship and banned systems of caste. Today, it's clear that that ban on systems of caste mandates constitutional protection for the marriages of LGBTQ couples, even though no one imagined in 1868, when the 14th Amendment was passed, that discrimination on the basis of sexual orientation was a form of caste. So again, the text hasn't changed, but our understanding of caste and of the world has changed. So on this particular issue, I part company with famous originalists like Judge Bork, Justice Scalia, and Justice Clarence Thomas. And I think it's instructive to explain where and why I disagree with them. And I think Akhil will agree with my statements on this. I believe Justices Bork, Scalia, and Thomas thought that what was controlling in a 14th Amendment case was the original expected application that the framers of the amendment thought the amendment would provide as to a particular issue, and not necessarily the meaning of the text. To explain why original expected applications are not necessarily binding, I want to go back to my comparison of the Constitution to being more like a shopping list than like a poem. Suppose your spouse gives you a shopping list and one of the items you're asked to buy is fruit. Your spouse loves apples and she expects you'll buy apples, but you prefer grapes and you buy them instead. Have you exceeded the scope of your power under the shopping list? Of course not. If it was apples that she wanted that so badly, she should have said so explicitly in drawing up the shopping list. By buying grapes, which you prefer, you remain within the power that's delegated to you. Now imagine your spouse says to you, we've been married for 25 years and you know that apples are my favorite form of fruit. You should have construed the shopping list to determine my intentions and not just the words I wrote down on the list. At this point, you respond that some days she eats apples and other days she eats peaches or oranges, and all you did was follow the list she gave you, and she has no right to be mad at you for not figuring out her original intent. You're clearly in the right here. Now imagine a different kind of a document. Imagine the sort of 10-page lease that some of you may sign when you rent an apartment building. And if you're like me, you probably don't read the 10 pages of fine print in great detail. If it turns out that there is, in fact, in the fine print, a clause that says you've waived your right to sue under this lease and any disputes between you and your landlord are subject to arbitration, you can't come back and say, oh, I didn't understand it that way, or oh, I didn't realize that was in the fine print. You're bound by the contract you signed. And the same thing is true, I think, with the Constitution. The framers of the Constitution put a text out there with a rule, and we are bound to follow the text and the rule that they enacted but not necessarily their original expected applications. This becomes really clear when we look at the 14th Amendment, which guarantees birthright equality and bans race discrimination and all other forms of discrimination on the basis of caste. There were a lot of people when the 14th Amendment was being ratified who went around saying, you should support the 14th Amendment, but by the way, it doesn't ban segregated schools and it doesn't ban anti-miscegenation laws. The 14th Amendment was subsequently enacted, and of course, the issue arose in Brown v. Board of Education and in Loving against Virginia, whether the 14th Amendment banned segregated schools and whether it banned anti-miscegenation laws. And the answer, I think, is that the text of the 14th Amendment creates birthright equality. It mandates a no caste principle. And this is the case even if the ratifying conventions didn't completely understand this, because it's the text of the Constitution that binds, not what people were saying to try to get it ratified. Under the parole evidence rule in contract law, it's the text of a contract which binds you, not the soothing reassurances of a salesman who you sign the contract with. Now suppose that the early practice under the 14th Amendment from 1868 to 1954 is one in which there's state-sponsored racial apartheid with racially segregated schools and anti-miscegenation laws on the books in 16 states. Does 3/4 of a century of practice trump the original meaning of the 14th Amendment? Of course not. The amendment banned systems of caste outright in 1868. Racial apartheid is and always has been a system of caste. So the early cases in state laws providing for racial apartheid are all unconstitutional and should be overruled. So constitutional interpretation is more like shopping list interpretation than it is like the interpretation of a poem or a novel. Literary interpretation puts a premium on creativity, imagination, novel readings of a text, and aspirations. Shopping list interpretation puts a premium on following the ordinary public meaning of a prosaic text. And so I submit constitutional interpretation is more like shopping list interpretation, subject to the two caveats I mentioned. Some of the texts are very old and they have to be applied to a world that's very different from the one in which they were written. And second, some constitutional language is deliberately open-ended, which invites changes over time. This is not surprising in a written constitution, which is both the oldest and the shortest constitution in the world.
Great. Thank you both. I wonder if we could just take a moment to maybe starting with Professor Calabresi and then have Professor Amar jump in, just to say a bit more about, so when we're looking for the original meaning of these textual provisions, what is it exactly we're searching for to bring out? I mean, the original public meaning, the original intent there, and then, you know, a little bit about how you think we best do that. You both in your scholarship really turn to history and the importance of history. A lot of, you know, current originalist scholarship turns more to dictionaries, texts, language, and the like. So I wonder if you could both just say a little bit more about, you know, exactly what we're searching for when we search for originalism and original understanding, and then what the process is. And then maybe we can get to questions of kind of how abstract and concrete, or really kind of push some of those questions a bit more.
Yeah, so you invited me to go first, so maybe I'll go first, and Akhil then can correct all the many mistakes that I will make, as he does in our seminar every week. You know, I think dictionaries are a helpful starting point. Dictionaries do reveal original public meaning to some degree. But I also think it's important to note that words are used in context and that texts like the Constitution have to be read holistically, that is, as a whole, not clause by clause or word by word. if you read the First Amendment word by word, you would conclude that it protects only speech and printing presses and not letters you wrote to a friend or a diary, much less a radio broadcast or an internet posting. So, literalism is not the same thing as original public meaning. I think the dictionary definition is a good starting point, but you have to look holistically at the text and at the role that that a clause plays in the text. I think that in addition to looking holistically, I think you have to. I think that it is sometimes relevant to know the purposes that underlie a text. I think with the First Amendment, understanding its purpose as being one of protecting freedom of expression is part of what tells us that it means more than just prior restraints. I wouldn't go as far as Robert Bork and say the First Amendment doesn't protect literature or philosophy or history because that's not political speech. And the First Amendment was meant only to protect political speech. I think the First Amendment protects speech more broadly than that. But I do think purpose is a modality of interpretation which can be used by originalists under some circumstances. I think very often clauses in the Constitution have a meaning that draws from other parts of the Constitution. So, to me, the $64 trillion question in the 14th Amendment is, what does the Privileges or Immunities Clause mean? And the way I would start by getting a handle on that is to say, hey, the words privileges or immunities are drawn from the phrase privileges and immunities in Article 4, Section 2 of the original Constitution. And there was case law interpreting that clause that the framers of the 14th Amendment knew about, talked about, and said was relevant. And what's more, the phrase privileges and immunities also appears in Article 4 of the Articles of Confederation, even before the Constitution was adopted. So I think that when one looks, not every clause will have comfortable ancestors that you can look to the way the Privileges or Immunities Clause does to help you in solving problems of interpretation, but some clauses do. And so I think that's another way in which one goes about interpreting it. I think the important thing is not to be distracted by isolated floor speeches, comments in the Philadelphia Convention, views taken by one person or by another, which may not be generally shared. I think that original public meaning is sort of a social construct, a little bit like the reasonable man in tort law or something of that kind. And so I think we have to go beyond the intentions of a few particular people to figure out what the social construct is. But looking at history and the intentions of some people can maybe help point us in the direction of figuring out what the original public meaning is. Akhil?
So I think I'm much closer to Steve than to Justice Scalia in this book. Justice Scalia, he had certain interests. He was really into words. He was into rules. He was into dictionaries. But that doesn't necessarily mean that the Constitution is all about just words. It's about sentences and paragraphs and indeed entire structures. Not all, Scalia believed that rules are rules and that principles are rules, but actually principles aren't rules. They're different from rules. So he took everything in the Constitution, he turned it into words. He's into dictionaries, so he said dictionaries define words and they have necessary and sufficient conditions and type boundaries. That's actually not how words work. Scalia, actually, in my view, didn't understand words. Everything was a rule, but actually that's not how the Constitution works. And he looked at dictionaries because he was into dictionaries. He's a self-described snoot. And he underattended to purpose and structure and actually history because he didn't know those things and love those things. So, Steve is nodding his head. The shopping list is not a bad metaphor. Most shopping lists don't have a structure or architecture, but a constitution does. It's got Article 1, 2, and 3, and actually the opening sentences of Articles 1, 2, and 3 actually read somewhat similarly, and there are differences. That's separation of powers. It gives some things to the federal government, some things to the states. That's federalism. It establishes certain relationships between the branches. That's checks and balances. These are structural ideas. They're not maybe captured by individual words. Scalia at his best saw that in a case like Morrison versus Olson. His best opinion is an epic dissent. But at his worst, he reduced everything to words and words to dictionaries. And he didn't apply that in the case of a private letter written from A to B, which was an example that Steve used. But if he was just a dictionary guy, well, a private letter isn't a printing press, and it isn't freedom of speech. And if you just looked at it the usual Scalia way, it wouldn't be protected. And you disregard the 9th Amendment that says they're unenumerated rights, which Scalia did and Bork did, you'd come up actually contrary to what Scalia himself says here, which is the private letters are encompassed, but that's because at his best, he followed Stephen's instincts and not some of his own rules. So purpose and structure are very important to me. Now, I'm going to give you some advice as someone who's been married 30 years. Depending on your spouse, I don't care if she writes fruits or apples. If she wants apples, oh, I'm going to bring apples even if she writes fruit. I do not want to sleep on the couch. Okay, I'm not mad at me. And so even when it comes to shopping lists, I care about original expected application a fair amount, and I won't find these in dictionaries necessarily, but I will find them in history and context, and it matters to me a lot what even the salesman tells me when he's selling me a car. So for me, the history does shape even the words because it's a relationship between a salesperson and a customer, especially if that salesperson wants to sell me something again next year or the year after that, or among people when they're adopting a constitution or amending it. And if they look each other in the eye and say, this means X and it doesn't mean Y, and then immediately after they say, oh, it means Y, haha, didn't say, Simon says in the text, oh, that's going to be difficult for them to adopt the next amendment and the amendment after that. So it matters to me a lot what were the central understandings of what was in and a clause and the central understandings of what it did mean and why. Steve talked about purpose a lot. So let's take 3 clauses of the Constitution. You hear them talked about all the time. Age rules. Well, 35 means 35. Well, of course it does. And it means calendar years and not Earth years and not moon years or, some sci-fi. But that's so uninteresting. The 35 means 35. I want to know why they said 35 for the president, why they said 30 for the Senate, why they said 25 for the House of Representatives. And it turns out when you actually interrogate that, and dictionaries won't tell you any of this. History will, and Scalia wanted to do dictionaries because he didn't know history. And Steve will confirm this. And Bork didn't know history, and Steve will confirm this. And Steve and I have studied history. 35, 30, and 25 were actually all about anti-dynasty principles. Who's going to be able to get elected to the House of Representatives at age 23? Well, it's going to be a famous son of a famous father, and they didn't like that, actually. And when I tell you that George Washington doesn't have any sons, and neither does Thomas Jefferson, at least ones legitimately that bear his family name, or James Madison or James Monroe, and that only Adams has a son, and his name is Q, as in W, and he becomes president. Oh, I've told you a lot about the founders' world. When I tell you that the Romans had a course of honors, and you were supposed to actually have there were certain offices that you held and you were eligible at different ages, and that they wanted their presidents to actually have gone through a public service so that we could judge whether they did things well or not. I've just told you why I voted against Donald Trump last time around, because he had never held public office. And the words 25, 30, and 35 aren't going to tell you that in dictionaries, but I'm really interested in the larger purposes. And of course, that doesn't bind me today. Everyone is eligible. He was 35, but I want to know why, if I really want to understand what the richness of this constitutional legacy, even if not all that is justiciable. So Scalia also looked at the Constitution too much just through the lens of the eyes of a judge. Okay, so it's too much about judges, rules, words, and dictionaries. And I'm saying no, it's about purpose, history, structure, holism, but I'm much closer to Steve. But if my wife says fruit and I know she really meant apples, I'm going to bring apples. Otherwise, I'm in trouble. I'm just giving you some life advice here.
Although that's an act of grace, not a mandatory.
Understood. I want to emphatically agree with Akhil on the Constitution and structuralism. I mean, my shopping list comparison was meant to shock those of you who think that the Constitution is, like a great poem or a great novel. It isn't. But it's also not really just a shopping list. As Akhil says, it does have a structure that coheres together, and Articles 1, 2, and 3 can only be understood together with one another. The enumerated powers can only be understood together with one another. The powers of Congress in Article 1, Section 8 are informed by the things the states can't do in Article 1, Section 10. Structure is a huge part of constitutional interpretation. Structure doesn't play a role in shopping list interpretation. So my metaphor there just breaks down. And I think that Akhil is also right that original expected applications are of some interest and relevance. They're not necessarily dispositive if they seem to be inconsistent with the best reading of the text. I think Akhil is clearly right that the text of the Constitution and the principles it stands for are much better than the Supreme Court opinions that have interpreted it over the last 230 years. And he wrote a superb foreword to the Harvard Law Review where he demonstrates why the text is much better than the case law. Anyone who wants to follow up on this webinar and understand the Constitution should read Akhil's book, America's Constitution, a Biography, which discusses the text of the Constitution. And they should then read his 600-page second book, America's Unwritten Constitution. And those two books together set forth a very, very sophisticated and well thought out theory of constitutional interpretation. Bork and Scalia were pioneers. They were so busy trying to defend the enterprise of originalism that they didn't have time to do it, or maybe they didn't have the interest in doing it. I think Akhil's right. I think to do originalism properly, you really do need to immerse yourself in history and understand the history of the period in which time is dealing with. But then you also have to realize that once you've figured out the original meaning of a text as it's rooted in history, you have to apply it to a world that is just very different from the way the world used to be even 30 years ago. So, for example, we all know that the Commerce Clause allows Congress to regulate commerce among the states. Well, there are more state line crossings in a federation of 50 states than there were in a federation of 13 states. That means federal power grew exponentially when the number of states grew. So there are all sorts of ways in which history is foundational and is the starting point, but applying it properly to our world is a complicated enterprise too.
Let me, first let me actually make one plug here that both Jack Pitney and I teach Akhil's America's Constitutional Biography in our Intro to American Government classes. But because you both actually hit something that I think is worth highlighting for the audience and students especially, and maybe you can talk about it in question and answers, and then I want to ask a final question before we open it up. And that's that Professor Calabresi just thought, agreed with Professor Amar that the text of the Constitution is better than the Supreme Court opinions. And Professor Amar, you noted that one of Justice Scalia's shortcomings really was that he was too much of a judge in some sense. And both of you, on originalist grounds, as I understand it, insist that the Supreme Court is actually not the final word on the Constitution, that the other branches of government have an equal right to interpret the Constitution and engage in some of the most important constitutional interpretations in our history. I'll just note, when you're both arguing about the First Amendment, if it took the court 150 years to get there, James Madison actually got there in the 1790s, defending a very robust understanding of freedom of speech that extended far beyond political speech from the beginning. And that would just be one kind of example, I take it. But maybe you can say something about that in the Q&A more, because I think that often comes as a shock to students and lay readers taught that the court is, and the Supreme Court's the way to understand the Constitution. But I want to ask just one last question, and that's that.
George, and not just Madison, but Jefferson as president pardoned everyone convicted under the Sedition Act by judges who rejected their First Amendment defenses. And Steve and I both think that that was one of Jefferson's great achievements as a president.
Let me add to the Sedition Act. Congress in 1798 passed the Sedition Act. President John Adams brought prosecutions under the act, and Federalist judges sentenced people to prison and time and fines under the act. So all three departments of government failed. What happened? We, the people of the United States, in 1800 elected a new president who rejected that interpretation of the Sedition Act, and he pardoned everyone convicted under the Sedition Act. And eventually Congress appropriated money to pay back the fines that had been collected under the Sedition Act. So at some level, ultimately, we, the people working through the three branches, are the interpreters of the Constitution. And it is possible for all three branches to get it wrong, as happened in 1798.
Well said.
So the last question, and maybe we could hit it just briefly, or maybe it could come out in comments, is, and it comes in part by thinking about the Obergefell decision, the decision that said prohibitions against same-sex marriage are unconstitutional. Both of you have defended that and defended it on originalist grounds. And lots of academic originalists follow that. And I wonder, to what degree there's a pretty robust distinction between originalism as an academic project and where, it is proliferating at law schools and outside of that, and maybe a disconnect with how originalism is understood in the political world. It's unlikely that most judges who are defenders of originalism would go along with you there. Maybe Justice Gorsuch, we'll see. Most senators who want to appoint strict constructionists, so a word Scalia rejected, or phrase Scalia rejected, in understanding himself, still carry on that language. And so is there a real kind of disconnect between originalism as understood by law professors largely, and originalism is understood not just in the public, but especially in the political world?
My thought on that, it builds on a story that I heard from Steve's uncle, the great Guido Calabresi, who was my court professor, later dean of the Yale Law School. And Guido was a prodigy. He's one of the two or three most extraordinary legal academics, really, of the last 60 years. And as a young person, he reconceptualized a field of law, torts. He went over to Europe once and shared some of his ideas, which shocked some of the German scholarly traditionalists. And one of them said to him, and Guido was at 28, 29, 30 something, said to him, "That is not the law." And Guido said to him, "Yes, but it will be." Academics today, I do think, will be influencing the judges, the originalist and non-originalist, of the next generation. So I think that's what you may see. And Steve put it very well, and he was channeling Robert Bork when he talked about applying eternal principles or fixed principles to a changing world. Here's what Steve and I believe on Obergefell, I think. And I think this is what you heard him say, and my way. The 14th Amendment was about birth equality. The first sentence says, everyone born in the United States is born a citizen of the United States. We're all born equal. We're born free and equal. Steve has written about how that idea that people are born free and equal is in many, many state constitutions, going back to the Virginia Declaration of Rights of 1776, the Massachusetts Declaration of Rights of 1780, and Steve would say in most state constitutions, all the way up to the 14th Amendment, there's this idea that people are born free and equal. It's a deep Enlightenment idea. It's a version of Jefferson's, we hold these truths to be self-evident, all men are created equal. Well, if you think we're born equal, what does that mean? Well, I think it means we're born equal, male and female, black and white, Jew and Gentile, in wedlock and out of wedlock, firstborn or fifthborn in the family. But I think today we might say we're born equal, gay or straight. But that's because today science and culture has an idea of people being born gay or straight. They may not even have that concept in 1868. Gaga had not yet written and sung Born This Way. But if you believe the idea is this created equal, birth equality, born equal, and now you have a different set of scientific and cultural understandings that people are born with a certain sexual identity. Personally, I'm being very honest here, I feel as if my sexuality is not really purely a matter of choice, that I was born a certain way with certain tendencies and inclinations. If I feel that way, if our culture is telling us that, if our science is moving in that direction, that's going to have implications as we apply this birth equality principle to a world with different scientific and cultural understandings.
Yeah, and I would add to that, I think it's very clear to me that the 14th Amendment bans sex discrimination as well as race discrimination. I think it did as an original matter in 1868 because Section 1 of the 14th Amendment talks about the right, all persons being born or naturalized or citizens of the United States. It says all citizens enjoy privileges and immunities, and all persons enjoy due process and equal protection rights. So there's no use of the word male or female there. But then when you get to Section 2 of the 14th Amendment concerning voting rights, the word male appears 2 or 3 times. So the framers of the 14th Amendment knew perfectly well how to say male when they meant male, and they didn't say it in Section 1, and that Section 1 rights, therefore, attached to women. That becomes absolutely self-evidently manifest once the 19th Amendment, giving women the right to vote, is ratified in 1920. If women can vote for president, governor, or senator, then surely they can make a contract or own property without their husband's consent. Justice Sutherland in Adkins against Children's Hospital in 1923 said that the differences between men and women have narrowed so much that they have now almost approached the vanishing point. Justice Holmes dissented in that case, quipping, "It will take more than the 19th Amendment to persuade me that there are no differences between men and women." Holmes was wrong, Sutherland was right. Well, if sex discrimination is banned, then discrimination on the basis of sexual orientation is banned. Because if you have a rule that says a man can only marry a woman, but a man cannot marry a man, you're making a sex classification. And if you think the 14th Amendment clearly bans sex discrimination, as I do, then by definition, it clearly bans sexual orientation discrimination. Now, I will agree with you that many conservatives in politics, including one of the Republican senators from Missouri, have denounced this. Justice Gorsuch was harshly criticized in June when he interpreted the Civil Rights Act of 1964 as ban on sex discrimination and as banning sexual orientation discrimination. But I think it's just plain the meaning of the words, and the fact that the people who wrote those words didn't understand that simply shows their limitations, but doesn't reveal anything about what the words actually say. I also agree with Akhil. He and I are talking to students, to young teachers, and to the next generation. And it is our idea of originalism that will be the future, not the idea that the senator from Missouri has right now.
You are your uncle's nephew.
Although I will just end on this. The senator from Missouri is of the young generation.
Yes, he was my student, as was his, a lovely bride, Erin Morrow Holly.
All right, well, thank you so much. Let's end the formal conversation on that and then turn it over to the student fellows for questions. Thank you both so much.
Thank you.
Thank you so much. The first question we have from the audience is from a student asking, what is more important in interpreting the Constitution, the author's intended meaning or the contemporary public understanding of the meaning?
Well, I think Steve and I both think that ultimately it's not what's in one person's head, even if that person wrote the words, it's in what the people understood when they ratified a document. And that is, we start always with the words that they agreed to. I've said, oh, I do care about what was said outside the text about those words and understandings and what were the agreed upon purposes, what was thought to be clearly in and clearly out by lots and lots of people, especially if those understandings were deal making and deal breaking. I think Steve came close to that position. He might give a little less emphasis to those things, but I think he himself would say if almost everyone who supported the document said it means this and it doesn't mean that, and those understandings were deal making or deal breaking, that judges, even if they're not strictly bound by that, especially in the early period, should give weight to, and just as we should in ordinary dealings, I think. He invoked the parallel evidence rule, but again, if you want to have a course of dealing with someone, if you want to make another contract and a contract after that, if you want to stay married to your spouse, and not sleep on the couch, you're going to pay attention to some extent, not just to what your spouse said, but to what she kind of meant, because there's an ongoing relationship. And so if at any moment you say, oh, you didn't say so, Simon says, mother, you didn't say, mother, may I think that you'll be accused of bad faith. And that's going to make it, one of the things that at least I think Steve and I, the reason we like originalism is we see America very divided, and we don't love that because we both love America. We're the children of immigrants. And we see the Constitution as a basis for people coming together. And that's not going to work so well if you pull a fast one on someone saying, yeah, I know that's what I said in the sales pitch, but it wasn't in writing, so ha ha ha.
Right. No, I would agree with Akhil on that. I think that it's not as much what's in the person's head as the sort of general social construct of what something meant at the time it was adopted. I think reassurances that are offered are relevant, but one then also has to look at how the principle that it was established applies later in time. One thing Judge Bork said about Brown v. Board of Education is he said, the framers of the 14th Amendment may have thought that racial equality and segregated schools were compatible, but 70 years of history had shown that that wasn't the case. And so that left the Supreme Court in Brown to choose which was the more important principle to the framers of the 14th Amendment. And clearly racial equality was the more important principle. And so the court was right to go with that. Now,
it was in the text.
It was in the text.
I agree with Judge Bork on that. Judge Bork's account of Brown versus Board of Education, I think, is quite a powerful one. It's very similar to my own.
Next question.
So next question comes from President Chodoff for Professor Calabresi. As one who reserves the robust right to interpret shopping lists creatively as non-exclusive, my question is, what is the basis in the constitutional text as written for originalism as a primary or exclusive method of constitutional interpretation?
Well, to begin with, the Constitution says in the Supremacy Clause that this Constitution and the laws made in pursuance thereof, and all treaties made or which shall have been made, are the supreme law of the land. So the Constitution itself tells us that this Constitution, which we know is a text and which we know can only be changed in a very difficult way using Article 5 amendments, is the Constitution and is the governing rule of the land. Now, I think one can answer this by I think the founding generation, in their early controversies about the Constitution, constantly tried to figure out what the original meaning of the Constitution was. This was evident in the debate over the Bank of the United States. It was evident in the debate that went on over whether or not internal improvements were permissible. It was relevant in the fights that people had about slavery. Throughout the 19th century, people focused on trying to figure out what the original meaning of the Constitution is. So, number one, the text tells us that it is the supreme law of the land. Number two, originalism, original interpretation and early practice suggests that originalism is the right approach. Number three, if you look at our history over the last 231 years, the Supreme Court has overruled leading precedents in at least 10 major areas of law. It's overruled Plessy against Ferguson. It's overruled Korematsu. The 14th Amendment has overruled Dred Scott. The 11th Amendment overruled Chisholm. Garcia overruled National League of Cities, which overruled Maryland against Wirtz. And Garcia is now essentially overruled by the sovereign immunity cases that make it impossible for state employees to sue in federal or state court. On the death penalty, I mean, the Supreme Court essentially banned the death penalty in Furman against Georgia, and 5 years later it changed its mind in reaction because of public response, and the death penalty came back to life, as it were. So our practice over the last 231 years is one of exalting the tradition of the written Constitution. So that suggests to me that the text of the Constitution, original understanding, and practice all support originalism. The final question would be policy considerations. Is there a policy reason to reject the original Constitution? Well, first of all, the answer is no, because the country is hugely successful in all the ways that I described. People are streaming to come in here and no one wants to leave. We have a stronger economy, military, population, technology, science, etc., than any other country in the world. So it's not as if we're living under the Articles of Confederation. But even beyond that, no one has yet been able to devise a constitution that works better, and that's not for lack of trying. I've studied 20 foreign constitutions in almost every major country, including 15 of the G20 nations, and for various reasons, none of them work as well. There's a reason why we defend continental Europe from Russia and the East Asian democracies from China. It's because our constitution works so well. So I think that all of these things put together are what make me an originalist. The text, the original understanding of the text, our practice, and the consequent policy considerations.
Well said.
So for the last question of the night, the question is, in a case like DC versus Heller, where the majority opinion and the dissenting opinion both appeal to historical context to justify their positions, how can an originalist find the correct answer? In other words, why are some originalist interpretations better than others, and how much historical expertise can the judge have in making these decisions?
Well, the obvious answer is that they have to read my books. And actually, because I'm an historian and John Paul Stevens is definitely not, and Antonin Scalia wasn't, and neither of those opinions is great. Scalia's is better. If you want to see the reasons why in great detail, read my article in the Harvard Law Review called Heller, HLR, which is Harvard Law Review, and Holistic Legal Reasoning. But forget the Second Amendment. Suppose we didn't have a Second Amendment at all. The 14th Amendment was all about protecting the fundamental rights of citizens. Steve said, oh, the words privileges and immunities had a history. Those words were used by previous cases, and he meant Corfield versus Yale, but actually even Dred Scott talked about privileges and immunities of citizens. And one of the privileges of citizens that Dred Scott talked about was the right to keep and carry arms wherever you go. And it said, oh, if blacks were citizens, they'd have a right to have guns, okay? And the framers of the 14th Amendment knew that Dred Scott had said that. So even if you didn't have a Second Amendment at all, just look at the 14th Amendment. So since you asked, and I'm right here at home, a picture is worth 1,000 words. Here's actually the picture from Harper's Weekly. This is the Freedmen's Bureau, and it's all about blacks having guns so that they can protect themselves against Klansmen. One picture, that's from 1866. That picture can just show you. Now, Scalia didn't do a good job, in my view, because he didn't talk about the 14th Amendment, because he wasn't good at intergenerational synthesis, about reading earlier amendments in light of later texts, and he should have. So the better opinion, frankly, is Sam Alito's. It's one of Alito's greatest opinions ever. It's a rather originalist opinion, even though Alito didn't join the court as an originalist. It's in City of Chicago versus McDonald. Steve Calabresi's work, I believe, is cited in these opinions. Mine is as well. So, and I think that's a better opinion because it talks more about the 14th Amendment. But suppose you didn't have the 14th Amendment at all. So suppose you didn't have the second. You get it from the 14th. Even without that specific history of the 14th Amendment, Steve says look at state constitutions to try to find out what are basic understandings of fundamental rights in America. Look at them not in 1868 or 1789, 90. Look at them today. You'll see that a right to have a gun in your home for self-protection is a fundamental right affirmed in state after state after state after state. I'll say it a different way for liberals. We liberals believe in a right of privacy in the home. We think that Griswold versus Connecticut is rightly decided. Now, liberals believe in sex in the home. Conservatives believe in guns in the home. I say this is America. Let them both have what they want. I say personally, I prefer sex, but hey, whatever floats your boat. But now I've given you 3 different ways, and I don't think Heller is Scalia's best opinion. I think Morrison versus Olson, his dissent, is far and away his best opinion. But even if there weren't the Second Amendment, there's the 14th and the right of blacks to have guns in their home for self-protection. Even if there weren't that, there are traditions of unenumerated rights informed by tradition and state constitutions that are relevant. And read the City of Chicago versus McDonald case for, I think, a compelling exposition by Justice.
Let me add to what Akhil said. I did a survey of state constitutions in 2018, and 44 state constitutions out of 50 in 2018 have a phrase that says, a well-regulated militia being necessary to a free state, the right of the people to keep and bear arms shall be protected. 34 out of 50 states say the right to self-defense is a fundamental right and you have a right to own guns. 34 out of 50 states. So this is an idea that's deeply embedded in state constitutional law. And you look at I've looked at state bills of rights in 1868 when the 14th Amendment was ratified. I've looked at them in 1791 when the Federal Bill of Rights was ratified. And consistently that right shows up in one form or another. So I think Akhil is clearly right on that. And I should add that, like Akhil, I also don't have a gun in the home. But I agree with him that sex in the home is protected, and that, that the right to privacy is a part of the Constitution. I think it flows from the born free and equal idea, in essence.
One final thing on that, again, about holism. Ever since Semane's case in 1608 or so, thereabouts, there has been in Anglo-American jurisprudence an idea that, and this is the phrase from the opinion, a man's house is his castle. There's
Right.
special rules actually about homes. A specific issue in Semane's case was the right of a homeowner to use deadly force, actually, to repel someone invading his home. The Second Amendment is there, but what's next to it? The Third Amendment, which is actually about how troops aren't supposed to be in your home. And then the Fourth Amendment uses the word houses. The Fourth Amendment actually talks about the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The Ninth Amendment says they're unenumerated rights. One way to understand unenumerated rights is to read between the lines of enumerated rights, the way Steve did when it came to a private letter. Maybe it's not strictly speaking printing press, maybe it's not strictly speaking oral speech, but you connect the dots, says the Ninth Amendment. Well, you connect the dots between the Second Amendment and the Third Amendment and the Fourth Amendment, and I think you do get a sense of, especially going all the way back to Semane's case, a right of a gun in the home, is what I've been defending, for self-protection. So it's a deep part of the Anglo-American tradition. And to repeat, I myself am not particularly a gun person, but Steve and I, we're not trying to offer an account of Amar's Constitution or Calabresi's Constitution, but America's Constitution. And that's what Bork and Scalia, at their best, were trying to do. They were saying, gee, it shouldn't just be about my subjective preferences. It should be something bigger than that. And Steve and I think it should be about this text, because it's what we as Americans have in common, Republican and Democrat, liberal and conservative, West Coast and center, North and South, city and urban. And America, if we're not going to fly apart, we're going to have to come together around something. And Steve and I think it should be basically around this.
I agree.
Well, on behalf of Claremont McKenna College and the Athenaeum, thank you all for joining us tonight. A special thanks to Professors Amar and Calabresi and to all those who sent in questions. Don't forget to join us for our next virtual Ath event, which will be on Monday, September 21st at 5 p.m. Pacific. Professor Sonia Lyubomirsky, Distinguished Professor of Psychology at UC Riverside, will address the how of happiness during COVID-19 and beyond. Thank you. Have a good evening.
Thank you.